You've agreed to all of this. Every time you tap I accept, sign a lease, or start a new job, you're handing away rights you didn't know you had. A coffee shop can ban you from making lattes anywhere else for 18 months. Your landlord can double your rent overnight with zero legal limit. And if you try to fight back in court, you already agreed you can't. Here are the things that are completely, perfectly, outrageously legal. A landlord in Miami told his longtime tenant her rent was going from $1,100 to $2,500 a month, a 127% increase. And then he filmed himself delivering the news and posted it on TikTok. The video went viral, but here's the thing that made everyone lose their minds. It was completely legal. 33 states have zero rent increase caps. None. Your landlord can raise your rent by any amount they want with as little as 30 days notice, and there's no reasonableness standard. Most of those states also have preemption laws that block cities from passing their own rent control, so even progressive city councils can't protect their residents. 44 million American households rent, and in those 33 states, there is no legal ceiling on what a landlord can charge you at renewal. Only Oregon has a meaningful statewide cap, and Washington just passed one in 2025. 2 states out of 50. So far, the system is working great. Adobe's most popular plan, Creative Cloud All Apps, is marketed as $54.99 a month. What they don't make obvious is that it's actually an annual contract billed monthly. So if you cancel early, you owe 50% of your remaining months. That's up to $385 in early termination fees. And an Adobe executive knew exactly what they were doing. In internal communications, they described the early termination fee as, quote, a bit like heroin for Adobe. They admitted there was absolutely no way to kill it off without taking a big business hit. Their word, heroin. And when you tried to cancel? The FTC found that Adobe used dark patterns to make it as painful as possible. The fee disclosure was buried in fine print or hidden behind tiny hover-over icons. The cancellation flow routed you through multiple confirmation pages, dropped your calls and chats, and bounced you between agents. Some people who thought they'd successfully canceled discovered Adobe was still charging them months later. The FTC sued. 2 Adobe executives were named personally in the complaint, which is rare. And in March 2026, Adobe settled for $150 million, $75 million to the Treasury, and $75 million in free services to customers. But here's where it gets weirder. Adobe has over 30 million paid subscribers. That settlement works out to about $5 per subscriber, the cost of doing business. Mercury's Coffee is a chain of 8 coffee shops in Washington state, about 120 employees. They required every single barista to sign a non-compete agreement, barring them from working at any other coffee shop within a 10-mile radius for 18 months after leaving. 18 months for making lattes at $17 an hour. When one barista, earning $17 an hour, left for a competitor a mile and a half away, Mercury's sued her. They also threatened to sue another employee who left to work at Starbucks. A Starbucks. As if the secret to a good latte was proprietary intelligence that could bring down the whole operation. Washington's Attorney General stepped in and forced Mercury's to void every non-compete and pay $50,000 in legal fees. But that was one coffee shop. Across the country, 30 million workers, nearly 1 in 5 Americans, are currently bound by non-competes. 30% of those cover workers earning less than $13 an hour. Hairstylists, janitors, warehouse staff, fast food workers. These clauses work through pure intimidation. Most low-wage workers can't afford a lawyer to challenge them, so they just comply. In April 2024, the FTC voted to ban non-competes nationwide. A federal judge in Texas struck the rule down 4 months later. And by February 2026, the FTC officially removed the ban from the books. So a coffee shop can still sue you for knowing how to steam milk. But before we get to how one company lost $12 million fighting its own contract, here's the one that makes all of this look small. Every year, employers steal $50 billion from their workers' paychecks. $50 billion. That is more than all the robberies, burglaries, larcenies, and motor vehicle thefts in the country combined, which total $12.7 billion. Wage theft dwarfs every other form of theft in America, and in most states, it's not even a criminal offense. And it's not abstract. Swahili Village, a restaurant in D.C., systematically paid servers as little as $5 an hour, including tips. 72 workers eventually won a $500,000 settlement. In Fresno, 32 restaurant workers at Lynn's Fusion won $2 million after being paid in cash, denied overtime, and skipped on meal break pay. The Department of Labor recovered $273 million in stolen wages in 2024 alone. And that's only what they caught. Wage theft takes a lot of forms, and all of them are legal to attempt until somebody gets caught. Not paying overtime, calling employees independent contractors to dodge benefits, requiring people to work through breaks without pay, docking wages for broken equipment. And the workers hit hardest are immigrant workers, who are terrified to report anything because they fear deportation.
So your rent can be doubled, your subscription can trap you, your job can own you, and your wages can be stolen. But what if you want to fight any of this in court? That's where the next one comes in, and it's the mechanism that protects all the others. $60 million American workers are currently bound by mandatory arbitration clauses. That means, on their first day of work, buried somewhere in the paperwork, they signed away their right to ever sue their employer in court. And it's not just employment. 826 million consumer contracts, credit cards, rental agreements, streaming services, contain these clauses. You've almost certainly signed one. And here's why companies love it. In 2022, across the entire United States, 80 employees total won a monetary award through forced arbitration. 80. The win rate for workers in arbitration is 1.6%. In state court, workers win 57% of the time. So the system that companies force you into is the system where they almost never lose. The arbitrators are paid by the company. The process is confidential, so even when a company loses, no precedent gets set, and no other workers find out. And the clauses include class action waivers, meaning workers can't band together. Each person has to file alone, pay their own fees, and go up against a company with unlimited legal resources. The CFPB tried to ban forced arbitration in consumer financial contracts in 2017. Congress killed the rule using the Congressional Review Act. The Senate vote was 51-50, with the vice president casting the tiebreaker. One vote. That's how close 60 million workers came to getting their day in court. So forced arbitration was supposed to be the ultimate weapon. File alone, lose alone, stay quiet. But then, 6,000 workers figured out how to turn that weapon around. DoorDash made every delivery driver sign a mandatory arbitration clause with a class action waiver. Standard stuff by now. If you had a problem, you couldn't sue, you couldn't join a class action, you had to file individually and pay a $300 filing fee. So in 2019, 6,250 drivers did exactly that. Each driver paid $300. Total cost for workers? $1.2 million. But under the arbitration rules that DoorDash had chosen, the company owed $1,900 per case in filing fees. 6,250 cases times $1,900. DoorDash owed nearly $12 million just in filing fees before a single hearing even started. DoorDash refused to pay. They missed deadlines. And then they tried something breathtaking. They asked the court to consolidate all 6,250 cases into one single proceeding. They asked for a class action, the exact thing they'd banned their own workers from doing. Federal Judge William Alsop saw right through it. His ruling was one for the ages. DoorDash, faced with having to actually honor its side of the bargain, now blanches at the cost of the filing fees it agreed to pay. No doubt, DoorDash never expected that so many would actually seek arbitration. In irony upon irony, DoorDash now wishes to resort to a class-wide lawsuit, the very device it denied to the workers to avoid its duty to arbitrate. This hypocrisy will not be blessed. DoorDash was ordered to pay $9.5 million in arbitration fees, and the strategy spread. Amazon, Uber, Intuit, Chipotle all faced mass arbitration filings after that. Some companies quietly removed arbitration clauses from their contracts entirely because the weapon they built to silence workers had been turned against them. The irony is complete. Every single one of these started with a clause in a contract that nobody read. Pact Alert reads your contracts and flags every obligation, every deadline, every hidden fee, so the fine print can't be used against you. Link in the description. What's something that's legal that you think shouldn't be? Drop it in the comments.